One of the most common questions that people charged with a crime ask is, can my charges be dropped? The answer is yes, but only under certain circumstances. In Florida, there are several ways a criminal case can end without a conviction. The first is called a nolle pros. This happens when the state attorney's office decides to stop prosecuting the case. A prosecutor may drop charges because of insufficient evidence, problems with witnesses, newly discovered information, issues with laboratory results, or constitutional concerns that weaken the case. A criminal defense attorney may be able to help by identifying problems with the evidence, presenting mitigation, and showing prosecutors why the case should not move forward. Another way charges may be dismissed is through a diversion program. Many first-time offenders may qualify for programs that allow them to avoid a criminal conviction. These programs often require conditions such as community service, classes, counseling, treatment, restitution, or staying out of trouble. If the person successfully completes the program, the state attorney's office will often dismiss the charges. These diversion programs essentially work like a contract between a defendant and the state attorney. The defendant agrees to complete certain conditions, and in exchange, the state agrees to dismiss the criminal charges. Another possibility is a motion to dismiss. A motion to dismiss asks the judge directly to end the case. One common example is a motion to dismiss based on Florida's Stand Your Ground law. If a person legally acted in self-defense, they may be immune from criminal prosecution. After an evidentiary hearing, a judge may dismiss the charges if the person is entitled to immunity under Florida law. Another example is a C4 motion to dismiss. This applies when there are no material disputed facts, and the undisputed facts do not establish a crime under Florida law. In other words, even if everything the state claims is true, the facts still do not legally support the charge. Criminal cases can also be affected by constitutional violations. Illegal searches, unlawful arrests, or violations of someone's right to remain silent may result in important evidence being suppressed or excluded. If the state cannot prove its case without that evidence, the charges may ultimately be dropped. One common misconception is that an alleged victim can simply drop the charges. In Florida, that is generally not how it works. Once charges are filed, the case belongs to the state of Florida, not the alleged victim. The victim's opinion may be considered, but only the prosecutor can decide whether to continue or dismiss the case. So, can a criminal defense attorney get your charges dropped? No attorney can ethically guarantee a dismissal, but an experienced criminal defense attorney can investigate the case, identify weaknesses in the evidence, negotiate with prosecutors, pursue diversion opportunities, file legal motions, and challenge constitutional violations. Every criminal case is different. Some cases are dismissed because of weak evidence. Others are resolved through diversion programs, successful motions, or negotiations with the state attorney's office. The right approach depends on the facts, the evidence, and the law. If you have been arrested or charged with a crime in Tampa or anywhere in Hillsborough County, speaking with an experienced criminal defense attorney as early as possible can help protect your rights. Call Hunt Law at 813-787-4849 for a free case consultation.